You're listening to Wiley's Political Law Podcast, a series of podcasts on election law, ethics, and government investigations. In each podcast, attorneys at Wiley, a Washington, D.C. law firm, break down an aspect of the political law landscape with our unique insight into issues faced by our clients.
Welcome, everybody. Today, I'm here with my colleague, Rob Walker, who is of counsel in Wiley's election law and government ethics practice. And I'm Carol Laham, a partner in the same old practice. So we're here today to talk about lobbying disclosure because it turns out we're at the time of year where both the Lobbying Disclosure Act reports are due, the quarterly and the semi-annual reports. And we thought it would be useful to give you an overview of the Lobbying Disclosure Act and what the requirements are for these reports. So I'm going to turn it over to my colleague, Rob Walker, by asking him the very basic. What is the Lobbying Disclosure Act?
Thanks, Carol. And this is an area of the Lobbying Disclosure Act, or the LDA, in which both you and I practice a lot. And if you, the listener, know that you have both a quarterly report and a semi-annual report due in July, you may not need all these basics, but it's good just to run through and give kind of the context. So the Lobbying Disclosure Act is the Lobbying Disclosure Act of 1995. It's been amended a couple of times since its initial passage, most importantly by the Honest Leadership and Open Government Act, or HLOGA, in 2007. And it is a pretty, I'll say, fairly basic scheme under which lobbyists and the organizations or clients for whom they lobby have to register and make periodic disclosures of certain information. And the registration is done through a form called the LD1 form, and that is done by the registrant, who may either lobby on behalf of different clients. That would be the case for a lobbying firm, and the firm would be the registrant for a number of different clients. Or in the case of an organization that employs an in-house lobbyist that lobbies for the organization, the registrant is the organization and the client is also that organization. And those entities that have in-house lobbyists just have the one registration. And there are a number of broad categories of information that get disclosed under the LDA. As we've already alluded to, there are quarterly reports. Since 2007, there are semi-annual reports. We're going to talk maybe a little bit more later on about the semi-annual reports. Just briefly now, they require the disclosure of certain kinds of contributions by both the registrant and lobbyists, individual lobbyists for a registrant. Perhaps more importantly here on the quarterly LD2 reports, those include disclosure of information, obviously including the name of the registrant and the client, the lobbying income if it is a lobbying firm, or the expenses for the relevant period, lobbying expenses if it's an organization lobbying in-house, names of lobbyists, general issue areas lobbied during the quarterly period, as well as a disclosure of more specific issues lobbied. That would be, in fact, more specific things like names of bills, particular provisions of bills if they are of, omnibus or broad bills, nominations, executive orders, regulations, that kind of specific information. The houses of Congress lobbied, the House or the Senate, and the names of federal agencies and departments. So there are some other information, but that's kind of a thumbnail of the major categories of information that gets disclosed on a regular basis. And the disclosures are made in reports filed electronically with the clerk of the House and the Office of Public Records of the Secretary of the Senate.
So, Rob, there's a few things you said that I wanted to drill down on, because I find that people tend to misunderstand some of the aspects of the Lobbying Disclosure Act. One is who registers, because it seems that lobbyists are under the impression that they themselves have to register. So could you talk a little bit more about how the registration works for lobbyists who are employed by a company?
Yeah, and I think you're right. I think there is that kind of a misunderstanding, in part because you hear people referred to as a registered lobbyist, and nobody wants to be. Well, a lot of people want to be registered lobbyists. It's a great thing to be, but
You don't want that scarlet L.
that's right. The press and some organizations, governmental watchdog organizations, have criticisms of registered lobbying. So for an organization with in-house lobbyists, it is the organization itself that registers. Now, the trigger for registering for an organization is if they have someone in-house who qualifies as a lobbyist. And there's a two-part test for who is a lobbyist. That is, the first part is that over any period of time, you engage in 2 or more lobbying contacts for that client, for the registrant, and whether in any 3-month period, consecutive 3-month period, you as an individual spend 20% or more of your time on lobbying activities. Now, I don't think we're going to go into here exactly what a lobbying contact and lobbying activity is, but this is just to say that that two-part test applies to the conduct of an individual in an organization. And if an individual passes those thresholds, they are a lobbyist, and the organization that employs them in-house must then register and be the registrant under the LDA. The lobbyist and any other person who's a lobbyist for that organization gets disclosed on the registration and quarterly reports by the organization, listed under the category names of lobbyists. But the lobbyists themselves, in this instance, don't register. I won't get into if you are a solo practitioner lobbyist, are you the registrant? Yes, that's a different category. That's not where you're working in-house for an organization, lobbying on behalf of that organization.
So there also seems to be some confusion, I find, about when to add a lobbyist to a report if a company already has registered as a lobbying entity. Can we talk about that just a little bit?
Yeah, so the time to do it is when you're already registered as an entity, registered as a lobbyist, you have lobbyists there. Suppose someone else at that organization, in your organization, is meeting the 3-part test. They've had, say, 2 lobbying contacts, and it looks like you know for a quarter, let's say, that their time spent on lobbying activity for your organization is going to be 20% or more of their time. So if someone, as they're working for you, meets those triggers, you should add them as a lobbyist for the period in which they meet those triggers. That's one circumstance. The other circumstance is if you hire someone else for the purpose of, and you have to register that person for actually within 45 days of their qualified. The other circumstance is, you don't register the person, you want to list that person.
There you go. See, you made the mistake that a lot of people make.
Do it for the quarter in which they're lobbying. The other circumstance is if you hire someone to be a lobbyist, that is, if you hire someone with the expectation that they're going to meet that 2-part test, 2 or more lobbying contacts over any period of time, 20% or more of their time in a 3-month period on lobbying activities for your organization, you should add them then in the quarter in which you've hired them. They're going to meet the threshold. At least that's my advice. You're hiring them for that purpose. You should disclose them then on those circumstances. Do you agree with that, Carol?
Well, my understanding always was that if somebody comes new to a company and is going to be a lobbyist, let's say this quarterly period started April 1st and it ends June 30th, and we know they're going to trigger, and they trigger in May, I always understood that they would be added at the end of the quarter on the quarterly report that disclosed the activity for April through June. So they would be identified on the report as new on the Q2 lobbying disclosure report.
Well, I think that puts much more clearly what I was kind of stumbling at saying. But so I think we're in agreement on that. And now that you've mentioned new lobbyists and listing people as new lobbyists for you as the registrant organization, one other thing that you list when you name a person as a lobbyist, list them as a lobbyist, is you have to also list any covered position they have had over the last 20 years. Covered position would be essentially any employment in the House or Senate for the last 20 years, either as a member or a staffer. And then also there are covered official executive branch positions, which are not as easily described and defined, but those definitions of covered officials are readily available. But that is, that covered position disclosure is important. You only do it on the first form in which the person appears as a lobbyist for your organization, but you've got to remember to do that.
So I wanted to also drill down on what gets reported in terms of bills. I mean, you referenced this and you said, let's say it's an appropriations bill and the company is not lobbying the entire bill. What is it that they should report there?
Well, this gets us around a little bit to the question of how do we know what's required under the LDA? And I won't get into that immediately, but I will say that based on the House and Senate Lobbying Disclosure Act guidance, the guidance of the Office of Public Records and the Clerk of the House in that regard is that the disclosure should be adequate such that basically a layperson unfamiliar with what your organization does and is doing can see on the face of the report, on the face of your disclosure, what you have really been lobbying on and interested in. So if it is a bill with numerous provisions and you've only lobbied on, it's got a dozen different provisions, kind of far ranging, and you've only lobbied on 2 or 3, you should identify the bill properly by name and number, and then also list the specific provisions that you have lobbied on. I will say there's a relatively low level of disclosure under the LDA. That's easy for me to say. I don't have to register and disclose my activities at all on a quarterly basis. But even with the relatively low level of disclosure under the LDA, there is a level of specificity required such that the public, and these forms are all available publicly. That's an important aspect here. They're available online publicly within a very short period of time when they're being filed. The member of the public has got to be able to tell from what you put on the form what you've actually lobbied on and you're interested in.
So my personal threshold for that in terms of reviewing these is if I read a lobbying disclosure report and have no idea what my client has lobbied on, I tell them it's not specific enough.
That's a good rule of thumb. I will refer everyone to you.
There you go. Sure. All right. So you made reference to this, but the Lobbying Disclosure Act is a statutory scheme.
Yeah.
So are there detailed regulations in the Code of Federal Regulations applying the Lobbying Disclosure Act and explaining them?
No, there aren't. And so the regulatory scheme, such as it is, that's imposed by the LDA, is a unique scheme, not to say a peculiar scheme, in that the regulatory scheme itself is overseen by Congress. It's not overseen by any executive branch office or agency. There are no detailed formal regulations that apply and interpret and explain the LDA. As I've already said a couple of times, I think the Senate Office of Public Records and the Clerk of the House do oversee and essentially enforce at least they're part of the enforcement mechanism of the LDA. Those two offices do issue and publish Joint Lobbying Disclosure Act guidance on a periodic basis. The last time such guidance was published was January 2017. Having said that, when there is a change, as there is periodically on a regular basis, to the monetary thresholds of income and expenses for reporting, those changes are published on the websites of the Office of Public Records of the Senate and the Clerk of the House. But the guidance itself, the published guidance itself, is issued only periodically. The two offices in the House and the Senate that I've talked to point out quite clearly in their published guidance, it doesn't have the force of law, doesn't have the binding effect on the U.S. Attorney for the District of Columbia. But having said that, it is a very, very useful document. Those two offices are very helpful. If a question arises, they're as helpful as they're able to be without a definite kind of regulatory scheme. So that's really the state of the regulatory framework there. It's a very unusual regulatory framework.
And I also agree that the House and the Senate are extremely helpful in giving guidance on what needs to be done in terms of the Lobbying Disclosure Act. So I encourage people to reach out to them if you need assistance. Of course, I encourage you to reach out to us as well. But
Yeah,
that's
me too.
Another story. Here's an important question for you, though, Rob. What is the relationship between the Lobbying Disclosure Act and the Foreign Agents Registration Act? Because I think everybody knows the Foreign Agents Registration Act has been very much in the news of late, and there seems to be a lot more enforcement going on there.
So the Foreign Agent Registration Act, or FARA, depending on whether you say potato or potato, that's a statutory scheme and a registration and disclosure regime that's been around longer than the LDA. That was first put in place, FARA, in 1934. It was also, however, significantly amended both by the LDA in 1995 and by Haloga in 2007. And under FARA, a person who acts as an agent of a foreign principal, and that's a key term under FARA, must register with the Department of Justice. There is an LDA, a limited LDA exception for that. So if the foreign principal in question, that someone is representing, is a foreign government or a foreign political party, and the other registration requirements are met, the person who represents that government or political party must register under FARA. You can't take the LDA way out if you represent a foreign government or foreign political party. But if the foreign entity or foreign principal that someone represents is a foreign commercial organization or entity, and it really is a private foreign commercial entity, not a government-controlled corporate entity. But if it is a private foreign commercial entity, there is an exception under FARA, under which registration and disclosure under the LDA is permissible. Now, you've got to make sure that all the specific circumstances are met. But so there is that kind of limited overlap and exception to FARA through which, in some limited circumstances, foreign private commercial entities may register and disclose under the LDA instead of under FARA. This is an area, of course, as you've mentioned, Carol, where there has been, that is FARA issues, an uptick in government and enforcement interest. So you don't want to get close to the line on any of these things we're talking about, but particularly if it's a FARA issue, you want to make sure that you are well advised and have been well counseled by experienced counsel in this area before you make the LDA election when you represent a foreign entity.
All right. Thank you so much for that explanation. I should have asked this sooner. because we were talking about adding people to the Lobbying Disclosure Act reports. How do you delist somebody? It seems like people forget to take people off once they've left the company or are no longer registered or no longer required to be identified as a lobbyist.
No longer registered. All right.
That's right. I slipped too.
Well, you're right. This is an issue that, I'll say a problem that comes up a lot, even in the best run organizations, and you've got to make sure that your list of lobbyists on your quarterly reports is up to date. And the only way to delist, and the other word for it is to terminate a lobbyist, delist I think sounds a little bit better, is to do it on the quarterly LD2 report when you know that person is going forward really either they're leaving your organization or you know that they're going to cease to be acting as a lobbyist, and they're no longer going to meet the in this case the 20% or more of their time threshold. And you do that on the LD2 form. There's a particular line for it. Persons no longer expected to act as lobbyists, or words to that effect. You've got to do it on that form. You should make sure, if you think the person is, they're a lobbyist one quarter and you think maybe the next quarter they're not going to be a lobbyist, but the plan is for them to really continue beyond that to be a lobbyist, leave them on. I mean, you don't want to put them on, take them off quarter by quarter. But if their person is no longer reasonably expected to be providing lobbying services, you delist them on the LD2 form. If you don't delist them, as you've alluded to, Carol, there are going to be consequences, because the list of people on your LD2 form, those persons listed as lobbyists, those persons are expected to file semi-annual LD203 reports. And if a person is still listed as a lobbyist on your form, even if he or she is no longer employed by your organization, they're going to be expected to file an LD203 as a lobbyist for your organization. And if they don't, you may get a letter from the House or the Senate saying, where is this person's report? And you're going to be, the organization, I should say, are going to have to figure out, how to solve that situation after the fact. So delisting in a timely fashion is very important.
Okay, so this was a perfect segue into the LD203 reports. And I do want to talk about, some enforcement a little bit later, but let's again start with the basics. What is the LD203 report?
Well, the LD203 report is a creature of HLOGA. It came into being with the Honest Leadership and Open Government Act in 2007. It is also sometimes called the contribution report. It's a semi-annual report filed twice a year on the 30th of July for the period January 1 through June 30, and on the 30th of January for the period July 1 through December 31 of the previous year. So it is filed, and here's an important point. Each registrant files an LD203 report. So in the case of a organization that has in-house lobbyists, that organization files an organizational LD203 report twice a year. But also each lobbyist listed on the organization's lobbying reports must also file their own personal LD203 reports twice a year. They are certain contributions, including federal political contributions, and I won't go into detail on them, but other categories of contributions that relate to contributions to or payments on behalf of or in the name of covered officials, either covered executive branch officials or covered legislative branch officials. So there's several categories of contributions that have to be disclosed. I should say with respect to federal campaign contributions, they've got to be disclosed even if those contributions are being disclosed as they should be by the recipients of the contributions. In addition to these disclosures of certain contributions or donations, each 6 months with each of the reports, there are certifications that must be made. These are certifications that either the organization's certifier or the individual on behalf of him or herself, when they file an individual report, has read and is familiar with the provisions of the House and Senate gift rules, and they have to, and gift and travel rules, and they have to certify that for the relevant period, they have not provided, requested, or directed a gift, including travel, to a member of Congress or a congressional officer or employee in violation of those rules.
So, these certifications, they're much simpler for the individual lobbyists because they know whether they've read and have reviewed the rules and understand the rules. But what about companies or lobbying firms? How are they going to certify on behalf of the entire organization? What's an appropriate basis for making that certification? This is something that causes a lot of angst in the community.
Well, and it's an important point because, this is when you make this certification, this is a statement to the government. You're essentially making it, if it's done knowing and willfully inaccurately, you can be subject not only to potential penalties under the Lobbying Disclosure Act itself, but could be a violation of the false statement statute, 18 U.S.C. 1001. There are consequences. And because there are no regulations that apply and interpret the LDA, there is no formal answer to this question. What you have to make sure you do is, as an organization, is have a system in place such that the person who makes this certification is able to make it on behalf of the organization on a reasonable good faith basis. And it's got to be somebody with some firsthand knowledge. How can you do it? Well, one way to do it is, you get internal certifications from anyone in the organization who is authorized to engage with federal covered officials or congressional, in this case, congressional members or staff, or anyone if you think that the people who may be providing such gifts are going to be clearly limited to your governmental relations, governmental affairs staff, you get their semi-annual certification annually, probably also along with your executive personnel and other people who may have occasional interaction with federal government officials, even though they may not qualify or pass that lobbyist test we're talking about. I mean, however you do it, you want to have a documented system and method that you follow, and it's got to be reasonably defensible that you're taking a broad enough sample to capture anyone likely to interact in this way with at least congressional members and staff.
So just to clarify here, when you say the person making the certification, you're really saying the person who signs the LD2 report or the LD203 report, correct?
That's right. That's the person who does it on behalf, the person who signs the LD203 report for the organization is the person who signs the report is the person making those certifications. So that person should be satisfied. Obviously, the organization should be satisfied, but that person within the organization should also be satisfied of the basis on which they're making that certification, and that it is a reasonable, good faith basis upon which they are relying.
So the bottom line on that one is don't just check the box, actually make sure that there's something behind it to ensure that the companies actually try to gather the information. Is that correct?
Yeah, that's correct. You want to work this all out and be as certain as you reasonably can be ahead of time, because if you discover after the fact that there has been a gift provided outside the rules, and particularly if it's something you should have captured, that is known about ahead of time, you can't really amend the certification to the LD-203 report, because then you're saying it was a false certification at the time. You don't want to get into that circumstance. You want to have a system in place internally where you're on top of any kind of gift giving that may come within the ambit of this certification, and that you are getting the input from ahead of time those persons who are in a position to be providing those gifts. You don't want to have to address it after the fact.
No, that would not be good for anybody involved in the situation, that's for sure.
Right.
So, Rob, let's just move on a little bit to enforcement of both the LD2 and the LD-203. You mentioned this earlier, that the House and the Senate have a role in the enforcement. So let's start with just their role. What is it that they do, and what should people do in response?
Well, and here, Carol, as throughout, I think your insights would be particularly useful as well. The House and the Senate, the staffs that are assigned to these tasks at the Clerk of the House and the Office of Public Records review the Lobbying Disclosure Act filings, and they review them for at least facial completeness of the form. They can't go and dig beneath the disclosures that are made to test the accuracy of them, but they do review them for at least facial completeness. And if there's something missing, they will get in touch by letter with the registrant and seek an explanation, and if necessary, an amendment of the form. And the best thing to do when you get such a letter is to review the situation, see whether there is inconsistent or incomplete information on the form. If there is, to complete it, correct it as quickly as possible. It would typically be through an amended form, or if there's some other explanation, in other words, you disagree, you think it is complete and accurate, you provide an explanation to the clerk and or the Senate. You've got 60 days to do that under the statute. If you don't, the House and the Senate may refer the matter to the Department of Justice, to the U.S. Attorney's Office for the District of Columbia, that has the role for DOJ in LDA enforcement. But what's your experience just initially in, when a registrant receives a notification from the House or Senate about an incomplete or an inconsistent LD2 or LD203 form?
So the LD-203 forms is where those letters tend to come from more than the LD2.
I agree.
And it's because they'll check the public record at the Federal Election Commission to see what's been reported there and compare it to what's on the LD-203 form by the individual lobbyist or by the entity that's engaged in lobbying as well. And you really do have to do your own comparison and see whether you've missed something. But it's also true, I think, that there's sometimes a timing difference where somebody has made a contribution and they'll disclose it in the period made, but the recipient committee has received it in a different reporting period. And June, July is a perfect example of that, where you would report something on your mid-year LD 203 because you gave it in June, but the recipient wouldn't report it until July, and therefore it's not going to show up until they report it. So sometimes it's just a timing issue. You just need to do the research and figure out, did you miss disclosing a contribution or not? But what I find to be a lot more common is that people simply forget to file their LD 203 reports. Or back to where we started this conversation, when somebody hasn't properly been delisted, they don't report because they know they're no longer a lobbyist, but their company has forgotten to take them off the report. So that's where it can get tricky, because sometimes the lobbyist is no longer with the company and you have to track them down to get them to file the reports. And that's
Right.
not always the easiest thing to do.
Right. If you can't do that, and if you're the registrant and you've made all the good faith efforts you can to track down that person and to notify them, that's about all you can do. And that's what you should say to either the House or the Senate, or if they've referred the matter after 60 days to the Department of Justice, that's what you explain to the U.S. Attorney's Office.
Mm-hmm.
I should say, I think it's clear that you're better off trying to deal with this within the 60-day, period with the House and the Senate. If it does go to the Department of Justice, it's not the end of the world. I mean, the situation can be resolved, and can be resolved, I think, fairly easily and clearly in most circumstances. Department of Justice enforcement of the LDA, as you know, Carol, has been, both civilly and criminally, has been fairly rare since, there have only been a couple of handfuls of cases of civil enforcement of the LDA since passage of the LDA. Most of them have been since HLOGA was passed, and those have all been for kind of what I call scofflaws.
I call them recidivist. They don't do it over and over and over again.
Right. They're almost asking for enforcement. So if you have a chance to resolve a situation, do it, and you can get out clean in most instances. And there's only been one criminal enforcement action under the LDA, as you know, and that came last year in a guilty plea by Jack Abramoff for failing to register for a client, knowingly and willfully failing to register. That's the criminal standard. It's got to be knowing and willful. And he has so far been the first and only person to face a criminal charge for a violation of the LDA. In fact, the sentencing guidelines don't even include the Lobbying Disclosure Act. They don't even address a violation of the Lobbying Disclosure Act. So,
I did not know that. That's actually pretty funny.
That's right.
Well, and the truth is that the Department of Justice, as well as the House and the Senate, they're just interested in getting the reports on file. They want public disclosure, and as long as you file your reports, they're not going to go after you. But
that's right. That's right.
If you year over year fail to report and fail to respond to them, you're going to get some sort of penalty.
Right. That's right.
Mm-hmm. Yeah. Well, I think we've covered a broad range of topics here today. I don't know if there's anything else you want to throw in for the good of the order.
No, only a couple of LDA nerds could say that what I'm about to say, this has been very enjoyable. So thank you.
Same here. Good luck, everybody, on getting those lobbying disclosure reports filed and timely.
Thank you for tuning in to the Wiley Political Law Podcast, brought to you by the attorneys at Wiley Ryan LLP. If you enjoyed this episode, we encourage you to follow us on SoundCloud. For additional resources and materials, head over to wiley.law. Thank you for listening. The views, information, or opinions expressed during episodes are solely those of the individuals involved and do not necessarily represent those of Wiley Ryan LLP, and its employees. The material contained in this podcast is not intended to be and is not considered to be legal advice. Transmission is not intended to create and receipt does not establish an attorney-client relationship.